Good afternoon. This is the clerk of the court, and it's 2 p.m. in Washington, D.C. Judge Pietsch, the conference is configured for oral argument this afternoon with recording and live video streaming now up and running. Counsel are prepared to argue, and all participants are ready to proceed.
Very good. You may call the court.
The United States Court of Appeals for Veterans Claims is now in session. The Honorable Coral Wong Pietsch presiding. God bless the United States and this honorable court.
Good afternoon. This is Judge Pietsch, and I'm joined by Judge Greenberg and Judge Jaquith. We are convened today via teleconference to consider arguments in the matter of Victor B. Skaar versus Todd B. Hunter, Acting Secretary of Veterans Affairs, case number 24-5887. Before we begin, I would like to officially acknowledge and welcome the appellant, Mr. Victor Skaar. We are pleased that you could join us today for oral argument, and on behalf of the court, I want to thank you for your service. Will counsel, beginning with appellant's counsel, please make your appearance for the record.
Good afternoon, Michael Wishnie, Veterans Legal Services Clinic, Yale Law School. With me today are law student interns Gabriella Hill, who will argue the motion, and Emily Elledge, who will argue the appeal. In addition, I'm joined by co-counsel Natalia Friedlander at counsel table.
Thank you. Counsel for the secretary. Would you introduce yourselves?
Good afternoon, Your Honor. Omar Yousaf for the secretary, and with me on second chair is Sarah Fusina.
Thank you. Today, we will be hearing arguments on a motion to dismiss and then on the merits of the appeal. The order of arguments for today is as follows. First, the Secretary's counsel will present their arguments on the motion to dismiss. The appellant's counsel will then have opportunity to present their arguments on the motion to dismiss. If desired, the Secretary's counsel may offer a rebuttal. The Secretary and the appellant shall each have 15 minutes. Next, the appellant's counsel will present their argument on the merits of the appeal, followed by the Secretary's counsel arguing for the merits. Finally, if they choose, the appellant's counsel may provide a rebuttal on the merits of the appeal. The appellant and the secretary shall each have 15 minutes. Now, I understand that Ms. Hill will present the appellant's argument on the motion to dismiss, while Ms. Elledge will present the appellant's argument on the merits of the appeal. Is that correct?
That is correct. It's Ms. Elledge on the appeal. That is correct.
I'm sorry, Ms. Elledge. Thank you. Okay, would Secretary for the counsel like to reserve time for rebuttal on their argument for the motion to dismiss?
Yes, Your Honor. We would like to reserve 5 minutes.
Okay, thank you. And would counsel for the appellant like to reserve time for rebuttal on their argument on the merits of the appeal?
Yes, Your Honor. 5 minutes for rebuttal for us as well, please.
Okay, thank you. Now, if counsel are ready, let's begin with the Secretary's counsel, Mr. Yousaf. Please proceed.
Good afternoon again, Your Honors, and may it please the court. Your Honors, the court should dismiss this appeal for a lack of jurisdiction for 2 reasons. First, the board's July 2024 letter is not a final decision. And second, the underlying claim has since been remanded to the regional office, which creates an additional jurisdictional hurdle because remands are not final decisions and the board no longer has jurisdiction over the claim. So appellant is essentially asking the court to accept an interlocutory appeal and issue an advisory opinion, both of which this court has recognized that it does not do. As to the first reason, Your Honors, as expressed in the Secretary's motion to dismiss, the July 2024 letter lacks all the hallmarks of a final board decision, and it cannot be considered as such. The letter addressed appellant's motion for a particular type of aggregation, specifically for class action of all polymerase veterans who have filed a claim. Your Honors, this was a purely procedural matter, like a motion for an extension or a motion for advancement on the docket. Statutory Section 7104D lists the requirements of a final board decision, which includes a grant or denial of benefits, or an explanation of appellate rights or review options. The board's letter provided neither. Moreover, the letter does not represent the culmination of the agency's consideration of Mr. Skaar's claim. Furthermore, the impact of the letter in this case is materially different from Cardoza and more like Heller. In Cardoza, the board letter refused to docket a notice of disagreement, which in effect rendered the underlying decision final, and was therefore a de facto denial of the underlying benefit sought, which was an earlier effective date. So the court explained in that case that the board's vice chairman who issued the letter had considered and decided the underlying claim. So for that particular scenario and that particular letter, the court found it to be a final decision because the veteran's journey for benefits had come to an end and his appeal had been extinguished. But in contrast, this case is more like Heller. Your Honors, the Secretary notes that he did not cite Heller in his briefs, but with the court's permission, he would point to that case here as instructive. So in Heller, the court specifically found that the board's denial of a motion for advancement on the docket was not an appealable decision because it did not involve a grant or denial of a benefit. It simply prevented Mr. Heller from moving up the docket and getting his actual board decision earlier. So the court explained that the letter was not a culmination of the agency's consideration of the issue, and that a writ in that case was a more viable option.
Mr. Yousaf, excuse me, do you embrace that part of Heller, that what should happen, what should have been filed here by the appellant was a petition for a writ?
Your Honor, if the claim was that there was an unreasonable delay, as was raised in the brief, then we do think a writ is a viable alternative here.
What if it's just the petition for, if it's just a petition for aggregation of a class?
Well, Your Honor, in this case, I believe a writ was filed previously and it was dismissed because the board had not issued a decision on the issue. So if it's just for a decision on the class, Your Honors, we think that the court, through its jurisdiction, may have a viable option to consider it, as a writ would present an additional mechanism to obtain jurisdiction.
And is it the Secretary's position that that is a more appropriate mechanism than the appeal?
In this scenario, yes, Your Honor. We think that the writ is more appropriate to address any possible misgrievances that the appellant may raise.
And so it's not the Secretary's position that there's no remedy at all?
No, Your Honor. We don't submit that there's no remedy. And in fact, we would note, as I planned on getting to, that the appellant, Mr. Skaar, would not be deprived an opportunity to raise this issue, because even if we dismiss here, if the board were to deny his underlying claim, then he can once again raise these arguments if he chooses to appeal the board decision. So he is not deprived of that opportunity to make those arguments.
But there are, as he's already discovered, certain problems, certain limitations with pursuing aggregation at the court level. Isn't that right?
Your Honor, what specifically would you be referring to?
Well, the issue that caused the Federal Circuit to send the case back to us for including for an over-inclusive class, we'll say, for the sake of simplicity.
Correct, Your Honor. So we do recognize that this issue was previously adjudicated by the Federal Circuit in the previous appeal. So we do recognize that case, but we would submit that the Federal Circuit's jurisdiction would be distinct from this scenario here, whereas the Federal Circuit, has specific jurisdictional grants that are unique to it. And so we would submit that that does not necessarily apply here. the court's jurisdiction is even distinct from the federal circuits as well. And while the court may hear class actions, Your Honor, that is distinct from the board's jurisdiction and the board's statutory authority to do so.
Counsel, sorry, did I interrupt you, Judge?
No, go ahead, Judge Greenberg.
Counsel, when did the events that gave rise to this case, excuse me, occur?
Your Honor, I believe it was 1966.
Can you tell me why the department or the VA has not made a decision with regard to this applicant, Mr. Skaar?
Your Honor, I certainly sympathize with the time that it has taken. I understand, and from my understanding, the board is still trying to develop the case to ensure that an optimum decision is achieved.
And what is it doing in order to, and over the past 50 years, is it 50 or is it 60? My math is a little off.
59 years, 5 days ago, I think, was the anniversary of the event.
That's right, closer to 60 years, and we have no decision based upon the inability of the VA to develop the case? Can you explain that? You realize we're a court of not only competent jurisdiction, but equitable jurisdiction to some extent anyway, and class action jurisdiction to some extent. But more importantly, we're here to see that there is an adequate, timely, and fair award to every deserving veteran. You don't challenge that this application is based on a service connection, do you?
Well, Your Honor, as an initial matter, I do want to clarify I don't believe Mr. Skaar's claim has been pending since 1966. I just mean that the unfortunate events that led to.
Yeah, but we're way beyond that.
So I would distinguish that the specific appeal, Your Honors, is about the class action and not necessarily about Mr. Skaar's individual claims. That's still being adjudicated before the agency.
My question is why? What do they have to do to adjudicate his claim? What's left for them to do? Meaning,
well, Your Honors, again, I certainly understand the frustration with the time it's taken, but the most recent remand, Your Honors, was to develop the case, provide a nexus opinion, and ensure that the case was properly developed below.
You still haven't answered my question. I may leave it at that, but my question remains unanswered. What are they doing? What do they need? Why is it taking so long?
Your Honors, again, I do apologize for the length of time. From my understanding, the agency is just trying to develop the case and ensure it provides the best adjudication that it can.
I don't know how old Mr. Skaar is, but I'm 82, and I'd like to be around for a decision in this case.
Yes, Your Honor, I understand that. And I would note that the board did grant his leukopenia case, his claim prior, somewhat recently. It is just his skin cancer claim that is still pending and hopefully to be adjudicated soon. Yeah.
All right, I'll leave it there for the moment. I have one other question. Would you object if the court considered the present application as being, in effect, a petition? If you agree that the petition mode is better suited to a resolution of this case. In other words, I don't want to get stuck on labels, which in my view are substantively no impediment. If we just consider this an application for a writ, what would be your review? What would be your opinion on that?
So, Your Honor, I don't think.
Are you in any way harmed if is the government in any way harmed if we consider this an application for a writ rather than an appeal?
So, Your Honor, I would make 2 points on that. The first would be, although we do concede that a writ may be more viable option than the motion or what appellant is seeking here, we don't think that a writ is warranted per se because he has not pled that. And we also don't think that it's ripe for a writ here because he would have to demonstrate undue delay for this specific issue. And
You don't think he can do that? 1966? Regardless of whether when he filed his claim for the second service connection disease or difficulty. 1966? They've had an awful long time. Even though it's underwater, they know where it is. Actually, haven't they picked it up? The wreckage?
I believe so. And again, Your Honor, I do understand that. But as far as the current motion for class action, Your Honors, that was a relatively recent motion filed in July. And the board did move on that specific motion. So we don't believe that there's cause for undue delay with respect to the motion.
All right, well, I'll leave it there. I'll leave it to my colleagues if they have any questions on this. Thanks.
Yes, Mr. Yousaf, currently does the board or does the VA have any rules regarding class actions?
No, Your Honor, the agency nor the board, they do not have any such rules.
If you were to adopt them, how would you do it?
Well, Your Honor, it would essentially have to be, so the secretary would have, I'm sorry, let me backtrack. There are no statutes that authorize class actions. So this would initially have to be either a congressional grant or these would have to be rules and procedures that the secretary would have to take the initiative of implementing under his rulemaking power. I would also stress, Your Honor, and I apologize, this is more so of a merits concern, but we would reiterate that while that would be the scenario in which it could be possible, we do not think that it is possible because it would conflict with the current statutes, the statutory framework and the regulatory framework. So we don't believe that it's currently possible to do that.
Thank you. Thank you.
Well, wait a minute. Sorry, Judge Pietsch, were you about to say something?
Go ahead, Judge Greenberg.
Well, having said that, counsel, what is the VA doing to assure either a statutory change or adopt a rule? The part of the overall statute is the VA, the government, is required to assist by statute, required to assist the veteran in perfecting his appeal. What are you doing to do that for Mr. Skaar?
Correct, Your Honor. We do recognize that by statute, the agency has to provide judicious decisions and speedy resolutions. But again,
it also has to assist the veteran in perfecting his or her appeal.
Yes,
statute.
Yes, Your Honor. I recognize that. However, there is no statutory mandate to use class action or implement class action. Your Honor, if I may have leave to respond, I believe I'm out of time.
Sure.
Yes, Your Honor. So,
right, Judge Pietsch, I didn't interfere.
No. Let's give the counsel 2 more minutes.
Yes, Your Honor. So again, we recognize that the secretary has various duties to provide for the veterans, which includes duty to assist. However, there is no likewise duty to implement class action procedures, and there are other mechanisms that are in place that the secretary does use to adjudicate these appeals in a timely fashion.
Well, that's all I have. I don't seem to be getting to the heart of the matter here.
Okay, Judge Jaquith, do you have any further questions?
I do, but I guess I'll hold them for now, considering so far over time.
Okay, thank you. Thank you very much, Mr. Yousaf.
Thank you, Your Honors.
Ms. Hill? Go ahead, Ms. Hill.
Thank you, Your Honors, and may it please the court. Gabriella Hill for Mr. Victor Skaar. This court has jurisdiction under 38 U.S.C. 7252 to review the board's decision on aggregation. However, I would like to start the discussion today with the All Writs Act. As Judge Greenberg alluded to, this case has been going on for far too long. The Palomares cleanup happened in 1966. Mr. Skaar first filed in 1981 for diseases related to radiogenic cleanup. In 1998, Mr. Skaar filed for leukopenia, which, as the secretary pointed out, was now finally resolved in 2024. Mr. Skaar filed for his skin cancer in 2013. It's 2025, and this case is still going on. Mr. Skaar has filed this motion for aggregation as a means to resolve the question underlying this case, which is the dose methodology that the VA relies on sound and scientific evidence? He has pursued other pathways. He has tried to do this every other way. This motion for aggregation comes before this court now because he is still pursuing answers to that question.
And how will aggregation assist in that pursuit?
Up until this point, the board has not engaged with the dose methodology and has not given an answer on the dose methodology. So aggregation is a way to ask the VA to finally answer that question. However, if this court does not find...
Didn't the court remand on that basis 4 years ago?
Remand on the basis for...
Problems with the dosimetry.
Yes, Your Honor. So the court did remand and the board still has not resolved that question. Without a class, the board won't engage dose methodology, making this tantamount to a denial of benefits for Palomares veterans, as we've seen in Mr. Skaar's case. However, if this court disagrees with the idea that this is a denial of benefits, it can still hear this case under the class action exception to this non-statutory requirement that a decision be regarding the grant or denial of benefits. Mr. Skaar recognizes that this court is limited in its jurisdiction to what was granted by Congress. The court and the Federal Circuit have decided a line of cases that have said that this is regarding a grant or a final decision must be on the grant or denial of benefits. However, other courts hold that class certifications and class certification denials are an exception to the general interlocutory appeal regulation that not happen. And while Mr. Skaar does believe that the denial of aggregation is tantamount to a denial of benefits for Palomares veterans, this court can grant an exception to the extra statutory requirement that a decision must concern the grant or denial of benefits and can review the board's decision on aggregation. There are good reasons for class action decisions to get an exception for the court's interpretation that a final decision is in respect to a grant or denial of benefits. The nature of a class action means that there are significant implications from the denial of the class certification. Class certifications are a procedural tool that are distinct from things like advancement on the docket, for example, as opposing counsel brought up in Heller. A class decision could resolve a major legal issue in this case. FRCP Rule 23F allows for interlocutory appeals on class certification decisions specifically in the discretion of the appellate court to account for the procedural tool that has broad implications for the affected class.
Counsel, how many people would be in this class, assuming aggregation was granted?
Your Honor, that's more of a question for the secretary. We've been in discussion with Palomares veterans over the years. However, the secretary would have a better knowledge of that.
Well, what's your knowledge of it? How many do you think are in it? Surely you have some concept of how many people are involved here. You're spending a lot of time and effort on aggregation. How many people we're talking about?
Hundreds. There were 1,400 Palomar's veterans. Mr. Skaar is 88 years old. There are other veterans still impacted. We're still in discussion with other veterans that were at the Palomar's cleanup that are still struggling to get their benefits.
All right. Go ahead, continue.
If there were ever a case to exercise the discretion to review the denial of a class certification, it is Mr. Skaar's. It answers the fundamental baseline question, whether the board can ever aggregate. The court has not had the opportunity to review the board's decision on this issue, and it should today. The board has stated that they do not have this authority ever, and all veterans deserve the right to know if the board is correct. Only this court can answer that question. Aggregation at the board has been brought twice in Mr. Skaar's case and once in another Palomar's veterans case, Mr. Edward Feely. Palomar's veterans have asked the board to recognize its authority to certify a class and to exercise that authority for Palomar's veterans. The court has not yet had this opportunity to review whether the board is correct. The secretary has strategically mooted out claims before and could do that again in Mr. Skaar's case. This court is aware of the strategic mooting by the secretary. Mr. Skaar's decision was final. It meets all the hallmarks of administrative finality and the 7104D requirements. It was the final decision on the motion for aggregation. There's nowhere else that we can bring this appeal. This can't be remanded to the RO, and the board has made very clear how they feel about aggregation. They do not believe they ever have the authority to do it. And so this is a question that this court needs to answer.
So is it your position that aggregation is the denied benefit here as opposed to service connection or a particular rating for Mr. Skaar's condition?
Yes, Your Honor. Without a class, the board won't engage the dose methodology, making it tantamount to a denial of benefits for the Palomar's veterans. However, again, even if this court disagrees with that, you can still find a class action exception as is consistent with other courts. And in the alternative, the All Writs Act authority can be in aid of the prospective jurisdiction of this court to hear this case. Courts can issue necessary writs in aid of their prospective jurisdiction, which might otherwise be frustrated by agency action. This stems from the court's inherent ability to manage proceedings. This court should exercise its authority of prospective jurisdiction here because the secretary has continually failed to answer the questions at the heart of this case. Despite multiple pending claims and appeals to the agency and this court, the secretary has refused to answer the question regarding the validity of the dose methodology used in evaluating Palomar's veterans' claims.
Ms. Hill, may I just interrupt you? With respect to Mr. Skaar's claim regarding leukopenia, which was granted, did that dose method have any play in that decision? Was that a consideration?
Your Honor, it's unclear why they
Granted, notwithstanding the dose methodology.
It was granted notwithstanding the dose methodology
Based on other evidence he produced.
based on other evidence he produced. So the dose methodology was not.
Okay, thank you.
Yes, Your Honor.
Ms. Hill, has the November 19th board remand for an examination on the etiology of the veteran's skin cancer rendered this case moot?
No, Your Honor. The case is still going at the RO.
Well, still going at the RO, but is it moot to us?
No, Your Honor. This court can still exercise its All Writs Act authority in aid of its prospective jurisdiction. If this court decides that it does not have jurisdiction presently, it can exercise the prospective jurisdiction. As Secretary's counsel said, if it did go up to the board and was denied there, then the motion for aggregation could come up as well. However, as in Erstbommer v. Derwinski, we don't need to predict what course Mr. Skaar's case will take in the future to have the authority to exercise the All Writs Act today.
But to do that, we have to construe the appeal as a writ, right? Because there isn't a petition, is there?
There's no objection if this court would consider this appeal a petition. Mr. Skaar did file a petition for mandamus last year, though, which the secretary then said that this court lacked jurisdiction when Mr. Skaar filed for mandamus last year.
That was the decision of this court on that writ?
The writ was mooted out by this letter that we're discussing right now, by the decision of the board that they lacked the authority to aggregate.
Oh, so there's no writ pending?
No, there's no writ pending currently.
We have no objection to deeming this petition for
We have no objection to deem this as a writ, though. This court can exercise its general All Writs Act authority to in aid of its prospective jurisdiction. The writ of mandamus is just one that could be used, however, can exercise the general All Writs Act authority.
But the standards are different, and you haven't submitted a writ, and neither side has briefed a writ, so that causes some concerns. I'm sorry, Judge Pietsch.
No, that's fine. I was going to ask you, what would be the heart of this writ if you wanted us to interpret this as a writ?
What we would like from the writ? Is that what you're
Yes.
asking, Your Honor? For this current question, it's that the court can hear the merits of Mr. Skaar's appeal, and that the board has the authority to aggregate.
Is that what you'd like us to do?
Yes, Your Honor. Mr. Skaar would like this court to hold that the board has authority to aggregate.
How do we get past the appealable final decision issue? That's where the writ comes in?
Yes, Your Honor, that is one option. However, this court does presently have jurisdiction under 7252 because the statutory requirements only require that there's a decision and a final decision, which Mr. Skaar has. And as is consistent with other courts, this court can make a class action exception to the on benefits requirement, the extra statutory on benefits requirement.
But you said, that this was a final, that there is a final decision, but a final decision implies that that's the end of the line, that's the end of the road, but this is not the end of the road for Mr. Skaar. Or is it, in your opinion?
Your Honor, without a class, the board has not engaged the dose methodology, so it has made it tantamount to a denial of benefits. There's no predicting how Mr. Skaar's skin cancer claim will proceed with the RO and the board.
Would he not have the opportunity to appeal?
Sorry, Your Honor.
I'm sorry, I must have interrupted something between you and the other counsel. But my question was, if Mr. Skaar goes through the process and the decision is that he still is not entitled to service connection for his skin cancer, and you're saying that if the metrics, the system is key to his claim, and he needs to have a decision on that because that's the entitlement, the benefit that you see as being at the heart of this case, this class action, this dismissal?
Yes, Your Honor. The class action dismissal was a final decision per the requirements of Bennett v. Spear and also the 7104D requirements. By saying that this is just a letter amounts to form over function, as was stated in Cardoza. All the hallmarks of administrative finality are here. There's nowhere else to bring the class aggregation denial except for to this court. And this court has never had the opportunity to review class action denials. And so that is an opportunity that you have today to decide if the board is correct in their analysis that they can never aggregate.
How do we deal with the Heller decision that the secretary cited, where in November, a panel of this court held that denial of a motion to advance a case on the board's docket does not involve the grant or denial of a benefit, because it's not the culmination of the board's consideration of the veteran's benefits claim.
Your Honor, class segregation can be distinguished from Heller because of the general principle that class decisions generally get an exception to the principles of finality in other courts. This court can use that same interpretation. If the court disagrees that this is not, that this is a decision on benefits, then it can use that exception, as other courts do, to hear, to decide whether the board is correct in their analysis.
But that exception is not in our rules, is it?
It's not in the rules, but you're not precluded.
And the case for appealability of advancement on the docket is stronger than that for appealability of denial of a motion to aggregate, isn't it? I mean, the advancement on the docket is a veteran's right that's as old as the board itself. It was included in the executive order that created the board in 1933, and it's established by statute and regulation and affects the timing of the provision of benefits. So it's established and statutory in a way that, to this point at least, class actions are not at the administrative level. How do we get past that?
Your Honor, I would like to just discuss Mr. Skaar's circumstances a little bit. He was one of the high 26 at Palomares, and he has had legal counsel. He has worked with nuclear physicists to bring his own case and has still not been successful. So in the case of other Palomares veterans, this is tantamount to a denial for them. If Mr. Skaar is still fighting to get service connection for his skin cancer, it's fair to assume that most other Palomares veterans also would equally not be able to get their benefits. So by not allowing aggregation here, it is tantamount to a denial of benefits.
Well, here's my question, Counsel. Are giving mature consideration to the decision of our colleagues anywhere, aren't we free to disagree with them and come to a different decision on the merits or on the law?
Yes, Your Honor.
We're not bound except by comity to respect the opinions of another panel of this court. Happens all the time in all the courts in the federal system. Are we free to do that here? Or in fact, are we free to come to a different conclusion than that in the Heller case based upon the facts of this case? I'm bothered, frankly, by the fact that a 1966 event, a serious event, is still unresolved in favor of, as you say, maybe 100 or hundreds of veterans. That alone should give rise to our inherent jurisdiction to correct it, to make sure things are done right. That's why this court was created, in my view. Not simply to, as one of my former colleagues said, put the veteran back on the hamster wheel. An 88-year-old veteran here, all of them must be in their 80s. I think we have an inherent jurisdiction to correct it. And I would invite everybody's attention to President Roosevelt and his signing statement of the GI Bill of Rights in June of 1944 for purposes of suggesting what the ultimate value the department brings to a veteran's case. So I think it's up to us if it doesn't exist already, to create or construe the law as appropriate for us to act and do the right thing, see that justice is done. It's not being done now. I can't for the life of me understand why the department has taken all this time without any, I haven't even heard today, any real statement of the reasons. It's, well, they're going back, they're going to develop it, they want to make sure it's a perfect case. I can't speak for him, but I believe Mr. Skaar would rather have a decision than a perfect analysis of why they came to the decision.
I'll add 2 more minutes to the timer for anybody else to ask questions or for Ms. Hill to have some closing statements.
Thank you, Your Honor.
Is there any reason to expect that aggregation will yield a faster decision than adjudication of his individual skin cancer claim?
Yes, Your Honor. I'll let my colleague discuss this further when she discusses the merits, but yes. Thank you, Your Honors. If there's no further questions, I'll end my time here.
Okay, thank you very much. Thank you, Ms. Hill. Mr. Yousaf?
Yes, Your Honors. So respectfully, the Secretary would,
Are we still on the motion here?
This is his rebuttal time.
Thank you, Judge.
Your Honors, the Secretary would put forth a few points here. First, the class action is a procedural tool, as we had indicated. It's not a benefit per se. The Supreme Court and the Federal Circuit have both recognized that it's a procedural tool to assist in the adjudication of claims. So the board's letter that denied the motion was not a final decision that would give this court jurisdiction.
But it was a final decision on the motion to aggregate, wasn't it?
Your Honor, it was a decision, but we would reiterate that this is not the end of the line for Mr. Skaar's ability to achieve or to seek benefits or to make that argument even. As we had noted, he can raise this argument again following the board's issuance of the board decision. So the motion, Your Honors, was not about.
But that's with the court. But that's with the court. That was the final decision on behalf of the board with respect to aggregation of claims. They're not going to aggregate his claim with others after they've granted or denied service connection for that claim.
Your Honor, we would classify it as a ruling, but yes, it was what the board issued in response to the letter. And we would reiterate that it has no impact on, respectively, has no impact on Mr. Skaar's individual claim for his individual benefits. It's an attempt to represent third parties and include them as well. It has no impact on his individual claim. We would also note, Your Honors, that I
don't think that judgment is accurate or the secretary's to make. The veteran seeks aggregation because he thinks it does advances. I mean, I'm sure Mr. Skaar is happy to help other veterans who are victimized by this, but his first interest and that of his counsel is for his claim. And so it seems pretty clear from the briefing that it's their view that his claim is aided by aggregation and the benefits that brings with it, including pooled resources and perhaps getting the attention of the entity that does the dosimetry work.
Yes, Your Honor, I can understand that. However, again, we would still liken this to Heller, where this was a procedural motion, or it was procedural in nature. It was not, the class action itself is not a benefit that would be provided, or a grant of benefits per se. And Your Honors, my colleague on the other side, she discussed in her presentation the benefits of class action, but she still did not address how the letter was a decision or how the court could obtain jurisdiction here. Furthermore, Your Honors, I would like to make 2 quick points on the writ. Although I did recognize that a writ could be a more viable option in the case of an undue delay, we don't think that that's warranted here. Respectfully, we would object to this transferring into a writ. It was never pled. The appellant chose to appeal the letter and did not file a writ. And we would also note that the prior writ was for the board to rule on the motion. So it would not be appropriate now for this current appeal to be transferred into a writ, given that prior history. Furthermore, Your Honors, as far as interlocutory appeals are concerned, that is the second reason that the second main reason that the secretary was going to say that there's no jurisdiction here. Contrary to what was mentioned, the court does not issue interlocutory appeals, and it had recognized this multiple times. Since the claim has been remanded, there would essentially be no benefit in that instance flowing to the veteran. This would essentially be an advisory opinion that would be provided to the board, which the court is not in the habit of doing. And Your Honors, if I may conclude on this last point, and it is that, as noted, once Mr. Skaar receives his final board decision, if it's a denial, then he can again make these arguments if he chooses to appeal that decision. So it's not the end of the line for him or his seeking of any benefits.
The one follow-up I have with that is that you've been speaking of writs in terms only of delay, but as you I think suggested about the prior writ, a writ can be aimed at the secretary's failure to do something, refusal to do something. In this case, aggregate claims. That, it seems to me, was and is the target of the veteran's action, however it's characterized, not undue delay, although, as Judge Greenberg has highlighted, there's plenty of that, plenty of delay at least, since the events happened in 1966 and Mr. Skaar's initial claim was filed in 1981.
Yes, Your Honor, and with the court's permission, I notice I'm out of time. If I may respond, we would, for that point, we would again just re-emphasize that the appellant once again did not plead this as a writ, and that this would also frustrate jurisdiction because the court, again, the court already issued a decision on that prior writ, which was to rule on the motion. And the board did address the motion. So I think that would be sufficient there.
Are there any other questions? I can add more time if there are any questions. Okay. All right. Having none, thank you very much, Mr. Yousaf.
Thank you, Your Honors.
Thank you. Okay. We'll next take the arguments on the merits, and we'll begin with appellant, Ms. Elledge. Go ahead, Ms. Elledge.
Good afternoon, Your Honors, and may it please the court. Emily Elledge, appearing on behalf of Mr. Victor Skaar. And I just wanted to confirm that my video is on for everyone.
I can see you. I can hear you.
Great. Thank you, Your Honor. The question before the court is narrow and strictly asks whether the Board of Veterans' Appeals ever has the authority to aggregate a claim or aggregate a class. This court should hold that the board has the authority to aggregate for 2 reasons. First, the secretary and the chairman of the board possess broad statutory and regulatory authority to manage board's docket organize appeals, issue guidance, and prescribe rules and regulations, including the manner and form of their adjudications, per 38 U.S.C. 501A and 38 CFR 20.2. Second, implementing class actions would be consistent with the existing statutes and regulations governing the board while advancing the values of consistency, efficiency, and access to justice for disabled veterans. The Secretary concedes that he and the board have broad authority to manage board's docket, organize appeals, and issue rules and guidance, but also claims that because no statute compels class aggregation, his hands are tied. To be clear, Mr. Skaar agrees that the board is not required to aggregate. He simply asks this court to hold that the board nonetheless possesses the ability to aggregate where necessary or appropriate to carry out the adjudication of claims. Aggregation of a class would not contravene the board's regulation mandating that its decisions are non-precedential. The decision made on behalf of a class may be applied only to that class. Aggregation would not preclude the veteran's right to one review on appeal, and aggregation would still require individualized determinations of adjudications on the merits. Here, aggregation would only serve to answer the common question of law for the class. Furthermore, aggregation would promote efficiency, consistency, and access to justice. Neither the Secretary nor the board needs explicit authority to aggregate. The board may aggregate in the absence of a formal rule. 38 U.S.C. 501 allows the Secretary the broad statutory authority to prescribe all rules and regulations which are necessary or appropriate to carry out the laws administered by the department, including the manner and form of adjudications and awards. No statute or precedent currently bars the board or the Secretary from exercising its authority to aggregate a class or aggregate like claims in appropriate circumstances. Section 501 does not restrict the Secretary's rulemaking authority to only those provisions that expressly grant authorities. There is a broad understanding of such authorities as long as they are applied in a manner consistent with the statutory scheme. Section 512A allows the Secretary to delegate broad rulemaking authorities to the board. This is then operationalized through 38 CFR 20.2, which allows the chairman to make procedure in the absence of a specific rule. It has been therefore recognized that within the governing scheme of the Secretary and the board, there are potential areas in which the chairman may prescribe procedures for the board. And Mr. Skaar is asking this court to recognize that the authority to aggregate a class resides with the statutory authority.
Ms. Elledge,
Yes,
may I ask this question? Do you think then, based on what you've been arguing so far, that it would be better, or the board should have implemented rules and procedures, rules and regulations on class actions for consistency, as you mentioned, or should the board just go case by case and then see what happens? Or is it better to have a set of rules in place?
Your Honor, the board could certify a class before any rules are in place for class certification. And eventually it would be better for the board to come up with some rules, the board and the Secretary, to determine the necessary rules for aggregation. However, the board does not need to come up with those rules before certifying a class, just as this court did not.
So maybe would it be better if you petitioned or requested the board to write and implement rules so that everybody could have benefit of it, rather than individually, spending a great deal of time and effort on this, as opposed to a petition so that the board could implement rules based on those authorities that you have cited?
Your Honor, a petition for rulemaking here would be futile, as the Secretary, as the defendant, has clearly presented his opinion on this matter. And instead, so no, Your Honor, we don't believe a petition for rulemaking would be the more expeditious route.
But if that's the case, how effective is our grant of if what you're asking us to do is to say to the Secretary, you do have the authority to aggregate claims. Or at least there's nothing that precludes you from aggregating claims. And there's, some general power grants in 501A and 20.2 that suggest that those are holes that the secretary can fill. But if the secretary has that may still be what we should do. But if the secretary has foreordained that that's not going to happen, it won't get Mr. Skaar the desired result.
Your Honor, the board in answering so the question that is appealed today, the board stated that it does not have legal authority to aggregate appeals or certify a class. Today, Mr. Skaar asked the court to determine that the board does in fact have the legal authority to certify a class. Mr. Skaar is not asking this court to determine whether or not the board should certify this class. That should be left to the board and the secretary.
Why isn't he asking for it? I mean, these cases have been around forever. Isn't it time to bring it to an end? Can this court issue an order granting the application for aggregation, notwithstanding the secretary's position? And if we have to interpret the letter as the final determination in order to give us jurisdiction, would you disagree with that?
I'm sorry, what is the question, Your Honor?
The question is, what stops us from issuing an order reversing what the board and the secretary have done and certifying a class, which includes Mr. Skaar?
Nothing would stop this court, Your Honor.
Is that what you want? You keep arguing to send it back with the legal determination that the board and the secretary have the power to aggregate. How does that advance the case of Mr. Skaar and others when it's clear we've got 50 years of resistance by the secretary to these claims? Isn't it better that we, who I would suggest clearly have the jurisdiction, certify the claim, aggregate the claims based upon the record that we have before us, or the record that's easily obtainable that's before the secretary, and proceed on that basis?
Yes.
Demand that order the secretary proceed on that basis.
Yes, Your Honor, that would be preferable for Mr. Skaar.
That's all I have.
Thank you, Your Honor.
Counsel, if you're asking that this court say that the board has the authority to aggregate, and then we would have to send it back to the board, and then the board would do their thing, and then it may or may not, but let's say it does come back on an appeal, but how much further ahead are we on that? And that's kind of connected to the question is, how would that benefit Mr. Skaar, and how would that help expedite this process? And let's give let's put five more minutes on the board. Go ahead.
Yes, Your Honor. It would certainly expedite the process should the court determine today that not only does the board presently have the ability to aggregate a class, but rather that the board should aggregate the class in Mr. Skaar and the Palomares in this case.
Are you asking us to make that decision that the aggregation should take place?
Mr. Skaar is asking, the threshold question before the court today is for the court to determine that whether or not the board presently has the ability to aggregate a class. Once again, the board determined that they have no legal authority to aggregate. Mr. Skaar is asking the court to find that they do in fact have that legal authority. Of course, if the court is willing to issue that not only they have that legal authority, but also that they should aggregate in this case, then that absolutely would expedite Mr. Skaar's case. Importantly, Your Honor, it's important for this case to be decided at the board. The question on behalf of the class is whether or not the dose methodology is sound scientific evidence, and that is a question that cannot be answered by the RO. And so this case must be determined, this question must be determined at the board on behalf of not only Mr. Skaar, but the class of Palomares veterans.
Let me ask this question. It was a question that was posed to your colleague in the argument on the motion to dismiss. Do you know how many there might be in this class that would be similarly situated?
We don't know the exact number, Your Honor. We believe, once again, there were well over 1,000 veterans that were at Palomares. There should be hundreds that would still be potentially could benefit from this decision. But I don't have an exact number today, Your Honor.
That there might be hundreds who have submitted claims and are in the process, or just are potential claimants?
Yes, Your Honor. Once again, the secretary would be the best source of knowledge for that. There should be hundreds that could submit claims. We don't know how many have presently submitted claims or where they are in that process.
But in your opinion, should the class include what? All Palomares veterans? What is your view of the class?
Your Honor, we would submit that the class should include claims that are pending at the AOJ, as well as those that might be at the board.
Well, what about the veterans who haven't submitted a claim? Should they be included? Remember, there's no statute of limitations on the filing of a claim, number one, and number two, the illnesses or the conditions that the veterans seem to be getting, such as skin cancer and other diseases or effects of this exposure, sometimes don't turn up till very late in the process. So wouldn't it be better to include everybody who was subject to service-connecting illnesses or disabilities as a result of Palomares in the aggregation, not just the ones who have filed claims as of today?
Your Honor, the class would need to consist of those that have at least filed a claim. So once they filed a claim, then they could be in the class.
All right, so you would like an aggregation more narrowly than the one I've described?
Yes, Your Honor.
Thank you.
What are we to make of the pendency of this issue in the House of Representatives, which has a bill proposing as an improvement to the board to amend 7104A to authorize the board chairman to aggregate appeals if the chairman determines that more than one appeal involves substantially similar questions of law or fact. And that bill has been pending since April, last April, without any movement. So what does that say about, if anything, about Congress's understanding of the board's existing authority to aggregate?
Your Honor, Congress is aware that the bill, H.R. 1917, would merely reaffirm the board's existing authority, not add an additional authority, so reaffirm the authority to aggregate this class. Therefore, the existence of the bill does not validate the Secretary's argument that that there is currently no congressional mandate for the board to hear a class, but rather that they are once again just reaffirming the board's existing authority to do so. Yes, Your Honor.
And one final question for me is, what did you want this court to do with respect to this issue?
The issue concerning class aggregation, Your Honor?
Yes, the issue of the merits.
Your Honor. This court should determine today that the board may aggregate claims as a class where class aggregation procedures can lead to more consistent, efficient, and effective adjudication because our nation's veterans and the Palomares class deserve no less. So here, if this court is so willing, we would argue that the court could then also determine that this class should be aggregated. And this decision would then be remanded back to the board.
Okay, thank you. Any other questions? Judge Jaquith? Judge Greenberg?
No.
Do we have any information on, and we've talked about a little bit, but numerosity, commonality, typicality, adequacy of representation, generally applicable relief, superiority, the things that go into determining whether certification of a class is warranted?
Yes, Your Honor, we believe in this case that we do. Mr. Skaar certainly would be the appropriate representative for the class, and the underlying motion does demonstrate this. The rest of the potential class, numerosity, typicality, adequacy, Your Honor.
You're talking about the motion that was filed with us, or the motion that was filed with the board?
The motion before the board, Your Honor.
And that stopped at the point where they said they decided they didn't have the authority, and advised you that they didn't have the authority, advised the veteran that they didn't have the authority.
Yes, Your Honor.
Thank you.
Okay, any other questions? Okay, thank you very much.
Thank you, Your Honor.
Mr. Yousaf?
May it please the court. If the court finds that it does have jurisdiction to consider this appeal, it should nonetheless reject appellant's arguments because the board did not commit an error when it concluded that it did not have the authority to implement class action or aggregate in the manner that appellant seeks, which again would be class action, because this would be inconsistent with the statutes and regulations that govern the board's jurisdiction, its operating procedures.
What statute?
So, Your Honor, looking at the statutory scheme as a whole, if we look at it as
Okay, what statute or statutes prevents this court from doing what the appellant wants?
So, Your Honor, initially we would look at Section 7105, which initiates appellate review by filing an NOD to the board. We would also highlight 5104 Big C, which lays out the appeal options that a veteran has in pursuing under the AMA. We would also lay out 7107, which lays out the docket order. We would lay out 7104, which lays out that a veteran is entitled to one review on appeal. So, Your Honor, if I may go through these briefly. So,
No, which one of the statutes that you just mentioned affirmatively provides that class action or aggregate action is forbidden as a matter of law, either at the board, the secretary, or certainly at this court level?
So, Your Honor, it would be forbidden if we look at the scheme as a whole. To answer your question directly, there is no specific statute that forbids class action, but when we look at the scheme as a whole, it would be inconsistent with the statutes that are in place.
Well, just taking you back a little bit in history, what was the first class action case in federal court? When? 1930s?
I believe so, Your Honors, yes.
And what was the statute that authorized it? Or what was the statute that said you could do it?
Your Honors, I apologize. I'm unsure.
There wasn't any. This was actually commenced, I think it was Rule 41 in those days, but that's how class actions came about in the federal court system. Why can't we do the same thing?
Respectfully, because Your Honors, again, not only do we have to look at the scheme as a whole and ensure that the scheme is working, but we would also
The scheme is not working if it's taken 50 years and we still have no resolution for an 88-year-old veteran. In fact, the statutes that say age of the veteran should be considered in resolving his or her action. Are you doing that here, or is it just following along the snail's pace of the department?
Yes, Your Honor. So Mr. Score's claim was advanced on the docket, given
81 claim, 1981. What claim are we dealing with? When did he file the claim that we now have? What year? 1995?
Your Honor, I believe it was 2013.
2013. All right. Every benefit of the doubt to the secretary. What's the difference between 25 and 13? 12 years. And that seemed extra long to adjudicate a skin cancer claim.
Yes, Your Honor. I understand the court's frustration with the
Well, it's not frustration as much as the question ultimately becomes, who's going to take care of this man? Your client is not speeding along. 12 years, skin cancer. Is Score's claim extinguished at his death under the statute?
Your Honor, not. I believe he would have opportunity if his dependents wish to pursue the appeal.
Well, dependents of a certain age or status, correct?
Right.
He's 88. You got to be under 21, don't you, to be a dependent or a widow?
Well, Your Honor, presumably if Mr. Score had any substitutes who could come onto the appeal or who may have qualify under the statute. So
what are they? What are the requirements under the statute to substitute?
Well, Your Honor, for example, if, they would have to pay his last expenses or things of that nature.
No. Aren't there age requirements? Age limitations on substitution?
Yes, Your Honor. I believe you have, for the children, there are age requirements. I believe.
What are they?
Yes, I believe you have to be a minor under, I believe, 21.
You happen to know whether that's the fact in Mr. Score's case?
I do not, Your Honor.
Why not? Shouldn't that be important to the secretary in determining how adequate an award is in terms of the speed of disposition?
Well, respectfully, Your Honor, the board did grant his motion for advancement. And so the board will consider, the need to provide a speedy decision here accordingly.
Let me ask you this. I'm sorry, you're doing a very good job representing your client, and I don't mean to seem obstreperous with these interruptions, but my question is there any person that you know that exists that would qualify without the government objecting to substitution for Mr. Score?
Your Honor, I am not aware. If Mr. Score has a spouse, presumably they may qualify. But as that issue was not before us, I do apologize. I'm not aware.
All right, go ahead.
Okay.
What about the four statutes that you named are impediments to class action? Since the board can advance a case for sufficient cause under 7107, wouldn't that address any issues with aggregation circumventing docket order rules?
Well, Your Honor, so the board is required to consider all claims in docket order per 7107, as Your Honor points out, and it may advance certain claims for various reasons, such as advanced age. But there has to be sufficient cause, and those specific exceptions have already been set forth by Congress in the statute. So advanced age, we do recognize, is one of those issues, but a class action, Your Honors, is not recognized as one of the exceptions to advance a case on the docket.
But that sufficient cause is not defined. So, you know, the size of the class could be a reason. And considering the nature of this class, you'd seem pretty likely that the age box is going to apply across the board. Since the event occurred 59 years ago, it's very unlikely that there is a service connection disability compensation rating claim by somebody who's under 75. They would have to have been under 16 when they were in service at Palomares in 1966.
Right, Your Honor, but the docket order would still govern because advanced claims are still kept in docket order. So they would just move ahead of other claims, but still be behind the other advanced claims. So they would just get pulled, in this case, they would just get pulled or put in a different pool from claims that are not advanced, if in that scenario.
Except if it was a class action case, wouldn't the whole case move together?
Well, Your Honor, I think in that case, the initial case would move, but again, they would still be subjected to the other claims that were the other cases that were preceding it on the docket, even if they were advanced. And in that case, you're violating the docket order. So again, Your Honors, the scheme, viewing the scheme, so a claim is initially adjudicated by the RO, and then the claimant has options to initiate appeal, which can include filing an appeal to the board under 7105. Class actions, as the appellant envisions, would disrupt that procedure because the RO is the initial adjudicator and the board is the reviewing body. So we cannot circumvent that. And as I had noted, Congress has also given veterans additional options for—
Well, you can. You have a regulation that allows you to do it, 20.108.
I'm sorry, Your Honors. So, Your Honor, I believe 2108 is, we would submit that that's limited to claims that are still awaiting adjudication. So it would presume that a claim is pending before the RO. And in that case, it's also simply to grant a benefit. So it's a very limited regulation.
But and I know we discussed this earlier, and you did not embrace this, but the benefit could be aggregation for the benefits that it is identified to have: efficiency and consistency and the fairness and backlog reduction that come with that.
Right. So Your Honor, yeah, we would disagree with that characterization because we would submit that class action or aggregation, even in a more broader sense, is procedural. We don't consider that to be a benefit under Title 38. So, Your Honors, Section 5104C, again, under the AMA, provides additional options allowing the veteran to choose how they wish to pursue their appeal. And if we were to implement class action as the appellant envisions, that choice would be stripped away. So veterans would be deprived of their right to one review on appeal. And it also risks tying an individual claimant to the results of the entire group. So the Supreme Court, Your Honors, has indicated that class certifications without rules for such proceeding that lack procedural safeguards may inhibit the rights of class members who are absent. So
why couldn't we issue an order on aggregation with those limitations or with that guidance?
It could be an opt-in class.
What's that?
It could be an opt-in class so
Yeah.
that the veteran herself or himself makes a determination of whether they want to throw in with the process that we're talking about.
Or opt out is another way of putting it.
So respectfully, in that situation, Your Honors, we would submit that the court, as an appellate body, it can't impose judicially created procedural requirements on the agencies that Congress has not mandated or that are not mandated by the Constitution. So we don't believe that that's possible here.
Counselor, could I ask this question? Do you know if any other administrative agency, such as the Social Security or MSP, have rules that address class action?
Your Honor, there are counsel and in the amicus brief, there were various agencies that were identified. And while those agencies do have grants of authority to implement rules and procedures, those agencies have taken the initiative to implement specifically class action procedures. Appellant has notified and identified various agencies in his brief, but the Secretary is not bound by those agencies, and the Secretary also cannot do that because, again, we submit that it would violate the statutes that the board is bound by.
So but you're saying the general authority, statutory authority to implement rules to conduct your and operate your business, so to speak, it doesn't. That forbids you. That's a forbidden. It forbids you from implementing rules to have, say, class actions, maybe amongst other kinds of organizational rules you might want to have or should have.
No, Your Honor, and if I may, I would believe I'm running out of time again.
Let's add 2 minutes, please.
Yeah. Yes, if I may answer your question, no. Just to clarify, the Secretary, Congress has given Secretary the authority to implement rules and procedures, but those rules and procedures have to be consistent with the statutes that are already in place. And so for VA, which is an entirely different scheme, cannot implement class action type procedures. So in the amicus brief, Your Honors, they cite to a case for the support that aggregation would be consistent with administrative law principles because agencies in general enjoy substantial authority to decide questions of procedures such as whether cases should be heard together or successively. But the board doesn't have this authority to hear cases however it wants. By statute, as we had discussed, the cases must be heard in docket order, other than outside of limited exceptions. So the underlying premise of what appellant's position is, it essentially forgets that the board is inherently different from other agencies. It's an inherently paternalistic scheme, and it has a completely different scheme. And the case, Your Honors, if I may, this is on page 4 of the amicus brief. It is FCC v. Pottsville Broad Corporation.
Thank you.
Yes, Your Honor. So again, we would just reiterate that appellant's position would not be viable here, as class action is not viable for the board. It would contravene the board's existing statutory framework, and so the board did not commit an error here. And we would reiterate that initially the court should dismiss the claim, and otherwise, if it elects to consider it, it should reject appellant's arguments.
Thank you. Any other questions? Okay, thank you. Ms. Elledge, rebuttal.
Your Honors, Mr. Skaar would agree with Judge Greenberg that the present scheme is not working. Class aggregation would preserve the right to one review on appeal. Class aggregation would comport with existing case management tools such as docket order, and there are safeguards in place for class actions. Class action would preserve the right to one review on appeal because the purpose here is to benefit the veteran. Any decision in this claim would not preclude the veteran's right to subsequent appeals to the board. The secretary here is attempting to deploy 38 USC 7104 and the veteran's right to one review on appeal against the veteran. 7104 is designed to provide the veteran with benefits and protections of the administrative appeal process. The board is authorized as an agent of the secretary to issue a final decision on behalf of the secretary as to questions of law or fact necessary to the resolution of a claim on appeal. Once again here, class aggregation would preserve the right to one review on appeal. Additionally, class aggregation would preserve the right, would preserve the need for each veteran to be have individualized determinations of their claims. And it would comport with existing case management tools such as the docket order. But of note, these case management tools cannot replace what class aggregation would bring to the potential class. Class aggregation would allow the veterans in the class to have access to the resources that have been used by Mr. Skaar and in order to answer the common question of law. To the secretary's comments.
May I ask what do you perceive as the common question of law?
The common question of law here, Your Honor, has to do with whether or not the dosimetry methodology utilized by the Air Force is sound scientific evidence. And this would apply to every veteran within the Palomares class.
How would you respond to the secretary's argument that class action might hinder some members of the class?
Yes, Your Honor. So there are certain safeguards in place generally for class actions. These are recognized in FRCP 23 and as well as the court's own Rule 23. These include things such as typicality, adequacy, and then, as has been previously mentioned by Your Honors today, other potential safeguards such as opt-out procedures. And so, additionally, Mr. Skaar is in the high 26 of the Palomares class. That means that he was in the top 26 of all the veterans present there in terms of the radiation exposure that he had. And so we would argue that if this is not benefiting Mr. Skaar, it is unlikely to benefit any other veteran in the Palomares class. Additionally, Your Honors, other federal agencies have aggregated without a rule to include this court following the decision and the Monk decision. The other federal agencies do include the Federal Energy Regulatory Commission as well as the National Vaccine Injury Compensation Program, who once again both did aggregate like claims without promulgating a formal rule. So we would argue that it could be done here. To respond to the Secretary's issue with advancement on the docket, Mr. Skaar and the class of Palomares veterans would actually be granted advancement on the docket under all three of the potential exceptions. So this is to include if the case involves an interpretation of law of general application affecting other claims, as well as if the appellant is seriously ill, and as all veterans in this class would be over the age of 75, this would apply, and then as well as for other sufficient causes shown.
Any questions? There are 30 seconds left on the clock. Counsel, any other comments from you?
Yes, Your Honors. In failing to address for years the question of the dose methodology, the Secretary has avoided taking accountability for utilizing an improper method to measure the effects of the Palomares incident on Mr. Skaar's health and, importantly, on the health of the entire class of Palomares veterans. This court should determine today that the board may aggregate claims as a class where class action procedures can lead to more consistent, efficient, and effective adjudication because our nation's veterans and the Palomares class deserve no less. If the majority of this court is willing to go further than that question, then we would welcome it today.
No further questions, no further argument from the appellant? All right, thank you very much. And the case is now submitted.
The court is in recess.